now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Court of Appeals session for this morning. I want to take just a couple of minutes before we get started and touch on the procedure that we're going to follow. And I want to be sure initially to thank Mr. Hibner for putting all this together. He's kind of been the quarterback of making all these video oral arguments go, and he's become quite adept at that and does a wonderful job at it. We appreciate him. We also appreciate the AOC staff. The technology people, the AOC staff, have worked wonders during this pandemic and have managed to allow us to continue to keep moving forward. Before we get started, let me introduce our panel. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Both of you are experienced practitioners. You know our procedure. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your argument. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. I think that you pretty much know how that operates. So without any further ado, Mr. Hibner, if you'll call the first case, please.
Jerry Tomlinson et al. Versus Renea Garber et al.
All right, we'll hear from the appellant.
May it please the court. My name's Larry Boyd. I'm a member of the Rogersville Bar and have been for several years now, 54 to be exact. But our case here before the Court of Appeals is an application for permission to appeal, which the court granted on this particular issue. It involves an issue.
Mr. Boyd, are you reserving any rebuttal time?
Yes, sir. I gave that to.
Okay. We need to know as well, though, please, sir.
3 minutes.
3 minutes. All right. Go right ahead.
And it involves the application for permission to appeal, which was granted by the courts, and it involves a relationship that sprung up between Sierra Smith, age 21, and Kurt McCracken, age 20, and they were never married. They had one child named Miley, who is the subject of this litigation, and for whatever reason, Kurt McCracken shot and killed Sierra Smith, and then shot and killed himself, and left this small child, 2 months old, at the time the murder took place. They were living in the residence of the paternal grandmother, and because of that, the child lived with a couple of months here and a couple of months there. And the long and short of what happened, my clients, the Garbers, chose to file an adoption petition, and the adoption was granted. During that period of time, there was some visitation between the appellees in this case, the Tomlinsons, and so the dispute has become the issue of whether the Tomlinsons have a right to visitation, which was filed in this case, and which is disputed by the Garbers. Now, admittedly, the Tomlinsons had visitation from a period of about, after the adoption was granted, for a period of about 2015 until 2019. And for whatever reason, that situation ended, and then that's when the Tomlinsons filed for an application for permission. After the Garber adoption was granted, our position is, since the order of visitation came from the juvenile court, that the application for visitation was barred because at that time the juvenile court lost jurisdiction over the case once the adoption was filed and granted. So our position was because the Judge Jenkins attempted to give them, order us to do depositions, we filed an application with the Court of Civil Appeals to give us grant us the application in which was granted. So
let me ask you a question about the procedure here,
Yes,
because I'm a bit confused. Initially, there was litigation regarding the issue of whether the statute gave the opposing side visitation, and Judge Jenkins ruled it did not. Is that correct?
That's correct.
All right. But then he goes on and orders depositions for the purpose of what?
Well, he took the position, and in his language at the hearing, he thought there was acquiescence. I'm sorry, I'll get it out in a minute.
That's all right.
Acquiescence on the part of the Garbers by allowing visitation to occur after the adoption was granted, but until this relationship between the Garbers and the Tomlinsons broke down, and that ended. So
okay, let me stop you there before we go any further. So he puts down an order and says perhaps there is a right to visitation by acquiescence or estoppel, or however you want to frame that. What were the depositions ever taken, or was any other action ever taken in that matter?
At that point, Your Honor, we filed a motion for an application for permission to appeal. The opposing side did not object to it, and so, Your Honor, this court, well, the Eastern Section granted it and granted our application for permission to appeal. And so our position is at this point that according to the statute under TCA.
Well, let me stop you one more minute before you, I don't want to take all your time, but I'm thinking about Rule 9, and I'm looking at the Rule 9 criteria, and I'm trying to ascertain how this case fits into a Rule 9 situation. Could you help me with that?
Well, our position was that they weren't entitled to take any depositions because under the TCA 36-1-116, once the adoption petition was filed, it cut off all rights of the Tomlinsons to apply for a visitation schedule, because the visitation schedule would, it became moot because it was granted by juvenile court, and it became moot once the adoption petition was filed and granted. So for that period of time, we think it's barred from the standpoint of being able to them ask the court for depositions when in fact that activity that took place in juvenile court was barred once the adoption petition was filed and granted. And we believe that the Tomlinsons, they're not a parent, and they're not entitled to notice, and so they have no rights from the standpoint other than the grandparents. They have no rights from the grandparent standpoint to ask for visitation. I mean, they're.
Let me ask you one other question, please, sir, and that's this. Is the initial ruling of Chancellor Jenkins that the statute does not allow for visitation, is that part of this appeal?
My feeling was that he felt like somehow or other, because the Tomlinsons had some visitation from the time of the adoption was granted until it ended, that somehow or other that constituted an application and acquiescence. But
I understand that, but he ruled based on the statute, the wording of the statute itself, as I understand it, that the opposing party, they were not guardians, they did not fall within the purview of the statute, and so consequently they could not gain visitation by way of statute. Is that part of this appeal?
That's a part of this appeal. They were not, and that actually comes up in the second part of this case. They were not found to be guardians. They were not found to be custodians, and their sole contact was this litigation. I mean, this application for for permission to appeal for visitation, when in fact they
Is this-
weren't the.
Mr. Boyd, I'm sorry to interrupt you. Does
sorry.
the second case that we're going to hear today, does that make this moot?
Well, personally, Your Honor, I feel that it's moot because this adoption was granted in 2015. There was no contest on the adoption, and for once a year expires, the adoption becomes final and it can't be attacked in any other way.
I'm sorry, go ahead.
Okay, but so our position is under TCA 36-1, 121F, it says specifically in there, even though there may be an incidental contact or continuing contact by permission, that there's no enforceable right that is created because the Garbers may have permitted this visitation when in fact, once the adoption was filed, anything that occurred before that was barred by the adoption. That particular section of TCA says in here, if I can, says TCA 36-1, 121F says any permission or agreement for contact shall not establish any enforceable right in anyone, including anyone other than a grandparent. And these people are an aunt and uncle, and they're not a grandparent. So our position is at this point that because the parents, the adopted parents, they should not, no one else can impose upon a natural parent something that should be allowed to be imposed by against an adopted parent, because actually an adopted parent from a legal standpoint takes on the same rights as an individual, as a natural parent. So we feel like from that standpoint that the Garbers were under no position, no obligation they were not, these other people were not guardians or custodians, or were never found to be guardians or custodians. And so therefore they had no right to notice, and they had no, if the Garbers wanted to let them visit by consent, yes, or by permission, consent, but if they wanted to stop it as adopted parents with the same rights as a natural parent, they had the right to stop it at any time. So the issue I think that Judge Jenkins had thoughts on was this issue of acquiescence, because he felt maybe because the Garbers had permitted visitation from this during this period of time, that somehow or other the Garbers had acquiesced to the contact between the Tomlinsons and the child Miley, and that's when we filed our application for permission to appeal, and which was granted by the court. And our position is acquiescence really gets to the issue of estoppel by adoption or adoption by estoppel. And our position is there is no such thing as adoption by estoppel. Under that Bank of Maryville case of some years ago, it specifically finds that you cannot have adoption by estoppel. So at this point, we submit that the Garbers did not have any right to lose. They didn't have to file something in juvenile court to terminate the visitation that had been permission allowed to permit to go on. They could stop it at any time they chose to do so, which they did. And as a result of that, we felt like the motion to dismiss should have been granted, and we should not have had to worry about having to do a deposition, when in fact under TCA 36.
Mr. Boyd, you used all your time.
Okay.
You've still got your rebuttal.
All right. Thank you.
All right. Let's hear from the appellee then. You're going to need to unmute.
Thank
There
you
you
for
go.
reminding me. I'm Rachel Ratliff of the Washington County Bar. I represent the Appellees, the Tomlinsons. While it is clear that 36(1)(121)A says that adoption terminates all other guardianships, that has to be read in conjunction with 36(1)(117)A that says all guardians have to be made a party to the
Okay,
adoption.
let me ask you the same question I asked Mr. Boyd. Apparently, Chancellor Jenkins made two rulings. One, that the statute did not allow for visitation, and then got into the acquiescence part of the argument. Is it your position that the statute is at issue in this case as well, that his initial ruling is on appeal?
I believe so. My reading of his opinion was that, number one, the reason he didn't allow them, say they didn't have standing to enforce their visitation, was because of the validity of the adoption and the time that has passed.
I didn't ask that very artfully. Let me ask it a different way. This is a Rule 9.
Mm-hmm.
And the only way that a Rule 9 is granted is by permission of the trial court and the appellate court. Is the question about the applicability of the statute, is it part of the issue that's been raised and been approved by both courts? Is it something you raised?
I did not. I believe the Rule 9 criteria that we would be looking at would be whether this would, I think Mr. Boyd's position is that to continue with depositions as to whether visitation should be granted falls under that needless litigation category. I don't believe that's the case.
But I'm just trying to make sure we understand where we are or where the panel is. You haven't raised anything in this Rule 9 application. Is that correct? On behalf of your clients?
Correct.
Okay. All right. You may proceed.
All guardians have to be made a party to the adoption. My position would be that the Garbers did have a guardianship interest. The juvenile court order from March 28, 2014 charged the parties to work together to help raise this child. And the very definition of guardianship in 36(1)(102)(25)A is a person other than the parent of the child appointed by the court to provide supervision, protection for, and care for the person or property or both of a child or an adult. And in this case, the court charged to the parties to work together to raise this child. And the fact that the court closed the case with it intending that this weekend visitation for the Tomlinsons would continue indefinitely, to me, says that charge to work together to help raise her was intended to be a permanent thing for both sides of this child's family to maintain contact with her, to maintain a relationship with her. And I believe that, yes.
Ms. Ratliff, excuse me, do you have any case law to support your position?
There are cases from other jurisdictions where someone who has acted either in loco parentis or as a de facto parent have been upheld as meeting the grandparent qualifications. So that's kind of where if they don't have a guardianship interest that would have forced them to be part of the adoption, then they at least have standing under a grant of valid visitation that was never challenged.
Were your clients granted any other decision-making responsibilities for the child other than their periodic visitation periods?
The order was very, very brief. The court didn't go into a lot of detail, but it was considered a final order. There was never a review or a reset, and it literally says the parties are to work together to help raise her.
Did the order grant decision-making authority to anyone on behalf of the child?
It actually listed the Garber's custody as temporary, but it closed the case and left that as the indefinite future that these Tomlinsons would have every other weekend, Garbers would have the weeks, and that both parties were to work together.
And who was to be responsible for the child's care as far as medical care and things of that nature?
It did not list authority for that. The order was literally just a couple of sentences. It
Did
was
anyone
not-
have to pay support?
No. I think both parties were responsible for the maintenance of the child monetarily and physically while the child was in their care. It almost looked to me like a parent, since there were no parents left for this child, that the court was intending to treat this as a parent versus parent type schedule where, the same thing we do on parenting plans. One parent gets every other weekend, the other parent's the primary residential, but they both share joint responsibility for that child.
And is that juvenile court order part of our record on appeal?
It is. It is.
Thank you.
So, moving on from that order was valid from juvenile court, giving them visitation. The time to challenge a grant of visitation to someone other than grandparents really was during that proper appeal period after the juvenile court order, which was never challenged. The Garbers had years that they continued to allow the child to visit with these people, to maintain a relationship with the Tomlinsons. That, as I said, is almost on a parent versus parent level. They had the kind of time that we see in a parent versus parent schedule to maintain that relationship. And they could have at any time during the years from 2014 all the way up to the adoption, they could have asked to modify that visitation. They could have asked to have it suspended. But instead, they continued to allow the child to visit for years, even after the adoption. I think the grant of visitation to the Tomlinsons by the juvenile court should be considered to fall under the grandparent visitation statute and thus survive the adoption, giving them that enforceable right to continue to pursue it. They are of the
Isn't the grandparent statute, though, to be construed strictly?
Well, there's a part at the end that says it in the right before the list of criteria. It says it includes but is not limited to a biological grandparent. To me, that means that there are other people who could fall under that criteria as long as they kind of act as a grandparent. And as I said, other jurisdictions have upheld this. Pennsylvania Supreme Court, Massachusetts Supreme Court. Peters versus Costello was a Pennsylvania case in 2005 where the mother's childhood custodian, not related to her, but raised her, actually qualified.
Let me stop you just a second. Are we arguing, I'm trying, my theories are getting mixed up here, I guess, is what I'm concerned about. Are you arguing the application of the statute now, or are you arguing the acquiescence?
I would argue the application of the statute. I think it goes beyond just the acquiescence.
But you didn't raise that as an appeal in this Rule 9, did you?
And I apologize. These are very intertwined for me. I can save that argument for the next half if that's.
I'm just wanting to make sure that you have not raised something specifically on appeal in this Rule 9.
No, and I guess the issue that would go to Mr. Boyd's issues raised on appeal were, number one, did they have standing under the statute 36-1-121? And then his second issue was, do they have standing by some other means? Okay. And so my answer to that would be that yes, under that grandparent visitation statute, they should qualify.
All right.
Other court, like I said, Pennsylvania upheld in their Supreme Court in 2005, someone who was unrelated to the child but had raised the mother. They held that person qualified as grandparent status to receive visitation, even over the objections of a parent, not even over the objections of a non-parent. This was over a parent's objection. Same thing with the Supreme Court of Massachusetts in Humans versus Ramos. They granted visitation to father's aunt and upheld it over the father's objection because the aunt had acted as the child's de facto parent with the father's consent. And I think that with consent is important here because the Garbers continued to consent to that visitation and relationship, allowing the Tomlinsons to, in essence, act as grandparents with the time that they were receiving. They actually received a lot more time than many grandparents, get with their grandchildren. They are of the same generation as a grandparent to the child. And I think that's the kind of relationship that they had. I think even because that grant of visitation from juvenile court was valid at the time. And we know that an adoption filing does suspend juvenile court's jurisdiction, it doesn't automatically invalidate all prior orders. It didn't, if their order was valid and it can be considered under this grandparent statute, then it should absolutely survive. The statute, grandparent visitation statute, is clear that that is one thing that survives an adoption by other relatives, which is what we have here. That's one.
Let me ask you, oh, go ahead. Go ahead, Judge.
So Ms. Ratliff, to follow your line of reasoning or what you're asking this court to do, you think that grandparent visitation should apply to any relative at all?
Only if they meet the other criteria of the statute, as far as relationship, time spent with the child, serving as a caregiver, the other factors in the statute. And I think that the time to challenge whether that was met or not was back when the juvenile court validly granted visitation. I think if it had been challenged back then, there might have been a question because of the relationship they had at the time. But since then, they've had this ongoing relationship for years where they've served as primary caregiver for weekends at a time. And so now what they had was validly granted and meets the qualifications of that grandparent statute. I just go back to that includes but is not limited to a biological grandparent. And so I would also say it wouldn't fit just any relative, because I think they do have to kind of be acting in that capacity of a grandparent. Like I said, the Tomlinsons are in that age range. They're in the same generation as grandparents to the child. And I think that was, their acting relationship to the child.
Let me follow up on part of opposing counsel's argument. The trial court said the statute was not applicable. The trial court then allowed an opportunity for discovery to take place regarding what visitation had occurred. Why is that relevant? And how does that create any rights here? I'm trying to figure out who's getting harmed, what the prejudice is, and why this is a appropriate Rule 9 consideration for this court.
Well, I think, again, the reason we would be looking at the Rule 9 was the question of whether it would be needless to continue to litigate this based on their status. Again, I think
that argument can be made in any litigation. If you just rule one way or the other, the case is over.
Correct. That's my, that reading the Rule 9 criteria, that's what I see that this would fit under. I think the Tomlinsons are the ones that would be being injured, I guess, or subject of harm if the court just dismisses this, based on the standing. The trial court never got to the consideration of them as under other statutes, under the grandparent statute, under having valid visitation that was granted to a relative, that then there was an adoption by other relatives. I think the court's avenue for reaching the decision they did, I don't think they considered the other applicable laws.
Well, I guess my question is there an actual dispute that would allow discovery to take place regarding the visitation that occurred?
I think because it is a relative versus relative, we don't have any parents left. And in a parent versus parent situation, the analysis is the best interest of the child ultimately. And the court never reached that part of an analysis. I think that would be what the depositions would have been for, was to analyze the relationship of both sides.
The best interest or the visitation that actually occurred? Where were you going there?
I think the depositions would have been to analyze best interests of the child, because that's the tipping point in any case where the parents are out of the picture and everyone's on equal footing. That tipping point is what's in the best interest of the child, and the court never reached that part of the analysis.
But Ms. Radcliffe, don't we have a parent here now? We have a legal parent.
Well, I think the fact that they waited until they were parents to make this decision when they had years to have challenged it, modified it, anything. And then the question of whether the Tomlinsons had adequate notice about the adoption to know that was even coming, and then visitation continued on. They've kind of waited until they were parents with a 1 year, I think they knew what they were doing, and I think they purposefully waited the year to stop visitation so they didn't have to go through the proper channels to modify it.
All right. Thank you for your argument. We will hear the rebuttal of the appellant now. Mr. Boyd?
Thank you, Your Honor. First of all, the Tomlinsons are not entitled to notice. They don't fit into the statute. The only people that are entitled to notice is a grandparent. And the other side, that the other time there could be a entitlement to notice is if there is a potential for an appointment of a guardian in a lower court or a designation as a custodian. The visitation does not write, and Judge Jenkins held that visitation, and he called it a blurb. We're into a little bit into the second argument now. Look, he called it a little bit of a blip that didn't rise to the level. Just of the nominal term of visitation did not rise to the level of being a custodial relationship or a guardian relationship. There was no court appointment to that effect at the trial on the trial level. Plus, the Tomlinsons never filed any kind of petition to intervene in this case, and we think the fact that they did not try to intervene until the level that it bars them from now proceeding, since the year for the year has passed, more than a year has passed since the adoption was granted. They can't come back now and try to attack the adoption and the aspect of the right of the adoptive parent to have the same right as the natural parent. They were under no obligation. The Garbers were under no obligation to go back to juvenile court and file a petition or a motion to set aside that a granting of adoption, since it was not done and the adoption was granted and there was no intervening petition on the trial level. So we think the Tomlinsons are out, and the motion for to dismiss because of lack of standing should have been granted at that time. So we believe at this point that the motion to dismiss should have been granted, and that under TCA 36-121F, that just because they allowed them to visit does not create an enforceable right under that statute. And it specifically says, I think I've got enough time to read this, providing further that the permission or granting or agreement to permit a visitation or contact shall not in any manner whatsoever establish any enforceable rights in the parent or guardian, the siblings, or any other related person. So if the court interprets that correctly, then it should close the case.
All right, folks, we appreciate your argument. Obviously, we're going to review the record. We'll consider the briefs, consider your argument, and we will endeavor to get you an opinion as quickly as possible regarding this matter. Ms. Tivner, I think, can we take, about a 5-minute recess? Would 5 minutes be okay with each of you to get your thoughts in order before we start the next argument?
That's correct with me, Your Honor.
Okay. All right. Let's take 5 minutes, Mr. Hivner, and then we'll come back and call the companion case with this, if that's okay.
Yes, sir. This court is now in recess for 5 minutes.